Hello, hello, everybody. Welcome back. Oh my, it's Friday. It is Valentine's Day. Happy Valentine's Day to you and yours. Hopefully, you are feeling the love from those people who are in your life. It has been a terrific day for me. I hope it has been for you too. Hey, you know what we like to do around here? We like to cut past sensationalism. We like to cut past fluff. We like to get into the nitty gritty. And the nitty gritty that we're getting into today is more about the murder of Dan Markel. Now, Dan Markel was murdered in July of 2014, and there are still things happening. Good things. Good things are happening. What's going on with my buttons here? Give me a second. Make sure my buttons work correctly here. There we go. Let's bring up that. There we go. So we're going to have a bit of a conversation today. We're talking specifically about the case against Dan Markel's former mother-in-law and accused, do we want to call her the mastermind? I don't know, a conspirator in his murder. Now, you guys remember there's like a big web. Oh, why is that there? Let's get that. There we go. There's a big web of people who are involved, but this is basically how the case breaks down. Okay. Dan was killed in 2014. It appears over, like, basically his former in-laws kind of wanting control of their daughter and her life. And because Dan Markel and his wife, Wendy Adelson, had children, they kind of it doesn't really matter. But there was this conspiracy, and 4 people have been convicted now in Dan Markel's murder, and Donna Adelson is the latest to be charged. Okay. Now, I know that that's not the best summary of everything, but it gets us to where we need to be. So that's where we are. Now, Donna has been charged because Donna is an idiot, because Donna is a complete and utter dillhole. She was actually apprehended on her way out of the country with a one-way ticket to, I think, the Philippines, if I remember correctly. And what is happening right now over the last week or so is Donna Adelson is asking the judge to let her out of jail. Now, the very first comment on this live stream before we ever came on the air or anything was from Queen Olive Ruth Ann. Holy cow, Queen Olive Ruth Ann. What a great handle. Hello, everyone. Happy Valentine's Day. I didn't think bail was allowed because of the charges. Well, see, that is the thing in the state of Florida and in most other states. There are places where if you do something bad enough, there is no bail. Other places they don't deny bail, but they make it like crazy, $25 million or something like that. But in Florida, there are crimes, like Ruth Ann said, where they're not bailable. However, there is a bit of a loophole. A loophole which is called an Arthur hearing. We're going to talk about that, okay? First, before we do, let's dive into some documents here. Excuse me, there were 2 things that happened last week. There were a couple of motions, okay? And I want to get to these motions. Okay, the first one was a suppression motion from the defendant. The defendant wants to, through her lawyers, to suppress certain evidence. And now we're not going to read this whole thing because we're going to read the Arthur hearing motion, but there are a few things that I want to bring up here, okay? And the reason I want to bring them up is just because they're illustrative of Gavin's iron law of criminal mastermindery, which is, if you think you have what it takes to be a criminal mastermind, that is evidence in and of itself that you do not. So I just want to read this because it tickles me a little bit. Not forgetting, of course, that there is a man who is dead. So I'm sorry that it tickles me, but it kind of does tickle me. But let's remember we've got a man who's a victim of a crime here. Okay. On November 15th, 2023, Mrs. Adelson was indicted for first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. So basically, you done killed someone, plus you conspired to done kill someone, and you asked somebody else to done kill someone. One piece of evidence the state intends to use against Mrs. Adelson is a recording made after a jail call ended on November 7th, 2023. The call was originally made by Mrs. Adelson's son, Charlie. Remember, Charlie was convicted of Dan Markel's murder. He goes to jail. Then they start talking on the phone. Every time the phone rings from Charlie, I've published these phone calls. You can go to the channel. You can listen to them to your heart's content. It starts out with, "Hey, this call's going to be recorded." Okay. So her son Charlie to Mrs. Adelson while he was incarcerated in the Leon County Detention Center. Oh yeah, he hadn't been convicted. He was being tried. He was just being held in the county jail. Although the call was dropped on the jail side of a call about 8 minutes into the call, the open line continued to be recorded. By this motion, Mrs. Adelson requests the court suppress the recording after the jail side of the call terminated and exclude it from the trial and any hearings in the case. A couple things that I highlighted. Okay, on November 7th, 2023, Charles Adelson called his mother, Mrs. Adelson, from the jail. The recording of this call is 25 minutes and 29 seconds in length. At the beginning of the call, an automated voice notifies the recipient of the call that the call will be recorded and it is not a private call. The recipient of the call is required to acknowledge the call will be recorded prior to speaking with the incarcerated individual. At 8 minutes and 5 seconds in the call, Mrs. Adelson realized that Charles Adelson is no longer on the phone. At that point, Mrs. Adelson reasonably believed that the call had ended and she puts the phone down. I don't know if reasonable belief. I mean, your phone tells you when the call is over, but okay. She believed that the call had ended. She puts the phone down. At the time of the call, Mrs. Adelson was present in her home with her husband, attorney Susan Brotman, and Miss Brotman's husband, Richard Skagren. I'm sorry if I murdered that name. After Charles' end of the call dropped, she continued speaking with Ms. Brotman, Mr. Chagrin, and her husband. At the time of the call, no law enforcement agency had obtained a wiretap pursuant to blah, 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 authorizing the interception of Mrs. Adelson's oral or written communications. Remember that so much of the case first against Charlie Adelson and the other conspirators and Donna Adelson is recordings where they're speaking in public. A bunch of idiots. But, okay, so they are saying, no, once Charlie was off the call, it was no longer legal to wiretap or to listen in, right? Skipping down to paragraph 23. Most jurisprudence the undersigned has identified discusses the inmate's limited privacy rights and the consent to the call being recorded given when the recipient of the call acknowledges the call will be recorded. Although Mrs. Adelson consented to the telephone call being recorded when she received the call from her son, what was the scope of her consent? The United States Supreme Court has held that the standard for measuring the scope of a suspect's consent under the Fourth Amendment is that of objective reasonableness. What would the typical reasonable person have understood by giving consent? The scope of consent must be considered in light of the consenting person's expectation of privacy. Blah, blah, blah. I don't know. Under the reasonableness standard, I think it's reasonable that the state got that consent. She consented to a phone call being recorded and did not terminate the call. But anyway, I don't think oh, there's a little bit. The question here is whether the consent of the recipient of the call gives for the call to be recorded terminates when the inmate side of the call ends. Typically, when two people are on the phone having a conversation where at least one of the parties is using a cellular phone and one end of the call drops, the call terminates. Again, though, come on. This isn't 1980. This isn't 1980 where both sides. What am I trying to say? A cell phone tells you when a call is terminated. You can look at it. It tells you when it's over. It usually beeps at you. So, yeah, probably not. Okay, certainly one can consent to their communication being intercepted by accepting a call from an inmate. However, that consent must necessarily be limited to consent to record the wire communication between the inmate caller and the one who consents to the wire communication being recorded. I mean, it's an argument, and it is an argument that can be made. I don't think it's going to stand up to scrutiny. Once the inmate side of the call ceases to function, the inmate is no longer on the call, and the recipient of the call believes the call is over. The recipient's consent for the call to be recorded must also terminate. That must be true unless law enforcement received authorization pursuant to the Florida statutes, which was not done in this case. I actually wonder if the system specifically does not terminate a call just in case they might be able to glean some more on the other end. I'm curious about that. But okay. So that was one of the motions that was set. The other motion that was set is called it's a motion to schedule an Arthur hearing. Now this is something that is I think, as a non-lawyer, once again, guys, unique to the state of Florida. I think this is a Florida statute. Yeah, State v. Arthur from whenever. It doesn't say when, but I found out what an Arthur hearing is. Now, this has to do with the title and thumbnail of this video. Does Donna Adelson have a chance to leave jail even though she has a non-bondable offense? Well, let me take you to this. And by the way, at the end of this document, it lists some of them, right? Like capital felonies, armed kidnapping, burglary with battery, SB, attempted murder with a weapon, armed drug trafficking, and murder. Those are all non-bondable offenses, right? And obviously, Donna Adelson qualifies under that, being charged with murder. So this is an article that was published by the Pumphrey Law Firm from 2022, but based on the other articles that I read, I don't think the law has changed much. So let's talk about what an Arthur hearing is, just reading this real quick, okay? When a person has committed a crime, they are typically able to get released on bond, which allows them to be released from custody. Bail refers to the money a defendant has to pay in order to get released from custody. If bond is granted, it means that the person who pays would be liable if the person released from custody doesn't return for the appointed time. In Florida, many crimes are eligible for release on bond. In fact, almost everyone has a right to bail. There are certain offenses, however, where that is not an option. This usually occurs when a much harsher crime has been offended. Usually, release on bond is not applicable to someone charged with a life or capital offense, meaning life in prison or capital punishment. That individual would have to remain in custody until their trial. And that is what has been the case with Donna Adelson. Okay. With the right help, the defendant may be able to attend something called an Arthur hearing. This is a hearing similar to a small expedient trial that may end up granting the defendant bond even with more extreme cases. By reviewing what an Arthur hearing is, along with what happens during the hearing, defendant can be better prepared if a hearing were to ever occur in their case. With the right legal help, again, this is a pitch from a legal firm, right? But release from custody through bond or an Arthur hearing can be a possibility. When a person has been arrested for a crime in Florida for a non-bondable offense, they have the right to ask for an Arthur hearing. A non-bondable offense is usually punishable by the maximum sentence of life in prison. Even if you are initially denied bond, a judge has the authority to grant an Arthur hearing. The reason for the hearing is for the judge to determine whether or not they're in their trial. Now, the motion that we went through before we're going to get to the second motion probably has something to do with it, right? If they can exclude that very damning evidence, could a judge, in the absence of that evidence, say, you know what, you should be able to bond out? Okay. To be granted a bond for a non-bondable offense, the defense attorney has to prove to the judge two things. The charges placed on the defendant do not have significant enough evidence to prove them guilty. So if the evidence is excluded, perhaps then there isn't enough evidence to prove beyond a reasonable doubt that they are guilty. Number two, the defendant does not pose a danger to society. We will get into that. I mean, of course, does Donna Adelson have any other daughters that are divorced from people in a custody battle? I don't know. I do know. But anyway, friends and family are encouraged to attend these mini trials to help prove the two above factors to the judge. If a bond is granted, then the person is released from jail until their criminal trial. One thing to note is that you do not have to wait until charges are formally filed to request an Arthur hearing, blah, blah, blah. Okay, what happens at an Arthur hearing? An Arthur hearing in Florida is set to see if the defendant is eligible to be granted bond. During the hearing itself, there are two distinct parts, phase 1 and 2. During 1, there's a mini trial held. Instead of a full jury, there's only one judge present. During this phase, the judge has to listen to and consider the testimony of the defendant. The prosecution has the burden of proof, meaning they have to show there is no question of the defendant's guilt. The prosecutor has to prove the crime was committed by the showing of a great presumption. During phase 2, it has to be decided where a discretionary bond is appropriate. Such things for the court to consider include the defendant's prior record, the seriousness of the crime, and whether or not the defendant poses as a flight risk or danger to society. I would say Donna Adelson does pose a flight risk, but she argues why she doesn't in the motion that we'll get to. Sorry, let me get a little lozenge here. If the judge believes the defendant is deserving of release from custody, he or she will set the bond amount. It is entirely in their discretion how much the bond will cost, and it is important to note that there is no restriction to the amount of the bond when it comes to capital felonies. With the help of a defense attorney, the bond amount, blah, 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 may be reduced. Again, this is kind of a pitch article. What are the benefits? We don't need to get on that. And these are the typical non-bondable charges like we went over before, okay? So when Donna Adelson is asking for a motion to set bond and schedule an Arthur hearing, now we have some sort of understanding what these terms are. Now let's take a break for a moment from reading. Let's head on over to your comments real quick and see, do other people agree with Ruth Ann? Man, are we skipping audio again? Let me turn off Wi-Fi. Maybe because I couldn't find any other gremlins. Sorry, man. Sorry. Internet's been laggy. Yeah, sorry, guys. Okay. Lee T. Lee T says, Gavin, my ear canals are super clean and prepared to hear your insights. Oh my goodness. Nifty 5050 says, Gavin, in my opinion, I think when she agreed for the call to be recorded, that was only for when she and Charlie were on the phone. Once the call dropped off, that consent ends. That is her argument. We're going to get into it. She was on her way to Vietnam. That's right. It wasn't the Philippines. Thank you, Heather. Oh my goodness. So funny. Demon Hugger's friend, Todd McGill. How dumb can someone be? My goodness, recorded phone conversation. I know, man. It's nuts. It's just crazy. Hopefully we're not lagging anymore, guys. I have a wired connection to my computer so that I have the fastest internet in my office, but I did have Wi-Fi on for airdropping and so forth. So hopefully that fixes it. Let's see if there's anything. Yeah, her flight was to Vietnam. Okay, it was Vietnam, no extradition. You guys are helping me out. Good job. Okay, let's. Gavin, sorry again. Yes, the daughter is Wendy. I don't know what is wrong with me tonight. Yeah. No worries. No worries, Heather M. Okay, so let's go ahead and head on over to this document right here. And we're going to go over pretty much the whole thing, okay? All right, the defendant, Donna S. Adelson, by and through underside counsel, blah, blah, blah. Okay. Asking to schedule an Arthur hearing. Mrs. Adelson was arrested on November 13th, 2023, and on November 15th, 2023, she was indicted for first-degree murder. I'm having a hard time now. First-degree murder, conspiracy to commit murder, and solicitation to commit murder. The bond amount listed on each warrant of these charges indicate FAR for first appearance required. At first appearance, Mrs. Adelson was denied bond on count 1. Bond was set in the amount of $25,000 for counts 2 and 3. On or about the 5th of December, the original counsel for Mrs. Adelson filed an emergency motion to enjoin the jail for an independent psychological evaluation or release to house arrest, based on alleged violations of Mrs. Adelson's Sixth Amendment right to counsel. I remember this. A hearing was held on said motion on the 11th. This honorable court found that there were no Sixth Amendment violations and entered an order denying the relief sought. On the 8th of January, a little over a year ago, a motion for substitution of counsel was filed, which was granted on the 9th. The attorney that became counsel for Mrs. Adelson was withdrawn from the case due to a conflict of interest on the eve of the trial. On September 17th, 2024, from a review of the records, it does not appear that the issue of bond was ever addressed by this new counsel. Due to the conflict of interest, Mrs. Adelson's pretrial confinement in the Leon County Jail was extended for approximately 9 months to await a new trial date. The state of Florida has not filed a motion for pretrial detention. The trial in this case is scheduled to begin with jury selection June 3rd, 2025. By the way, if I recall correctly, the conflict of interest there was that her attorney was the same attorney that represented Charlie Adelson. Am I remembering that correctly? And Charlie Adelson would be called as a witness for the prosecution. It was weird. So it'd be like Charlie Adelson's defense attorneys cross-examining him as a prosecution witness. It was something like that. Okay. General statement of facts. July 18th of 2014, Dan Markel was killed while sitting in his car in the garage of his Tallahassee home. Professor Markel was a prominent law professor at Florida State University College of Law. The Tallahassee Police Department began an extensive investigation which involved the FBI and law enforcement officers in multiple jurisdictions. On July 17th, 2015, TPD released new details of the investigation. You know, I'm not going to go through all these. Luis Rivera, blah, blah, blah. Yada, yada, yada. Okay. The facts upon which the state of Florida indicted Mrs. Adelson was indicted for murder, conspiracy, and solicitation include substantially that Mrs. Adelson made derogatory comments about her son-in-law during the course of the divorce proceedings between her daughter and Dan Markel prior to the homicide. I don't think that that's a fair characterization, but okay. That she spoke to both her son Charlie and her daughter Wendy Adelson on the morning of the homicide. Let me bring this up. That law enforcement conducted a bump demanding money from Mrs. Adelson after the homicide, which she did not pay. That she signed paychecks out of her son's business at his direction to Catherine Magbanwa after the homicide took place and that she attempted to vacation in Vietnam. And that she attempted to vacation in Vietnam? She had a one-way ticket. She was not attempting to vacation in Vietnam. What? Oh my goodness. That a country that does not extradite more than 9 years after the homicide. Come on. I mean, we want her to have a good, vigorous defense, but come on. She attempted to vacation in Vietnam, you know, right after her son was found guilty in conspiring with her to murder Dan Markel. Yeah, she wanted to vacation there. Oh my goodness. That is so funny. Man, I really hope that the lagging issues have fixed. Can you guys tell me if I'm still lagging? I want to make sure that let's see. Vivian says audio skipping is fixed, no audio issues. Okay. Good. Fixed for Janet. Okay. Thank you guys. I think that was it. I think I had my my Wi-Fi enabled. Maybe that's what it was yesterday too. Okay. Let's see if there are any other. I'm sorry, the attempted to vacation. Oh, cracks me up. They attempted to vacation. Okay. That is great. All right, let's go back. Here we go. Incarceration issues. Mrs. Adelson is a 75-year-old female with typical medical issues of aging, exacerbated by the conditions of confinement, hearing problems that are compounded due to a medical issue that cannot be addressed by medical personnel at the Leon County Detention Facility. Prior to incarceration, she saw an ENT every 3 to 4 months to have her extremely small ear canals cleaned out with proper equipment, as general flushing will not resolve her issue. Okay. Severe pain from a pre-existing medical condition in her back and legs that cannot be relieved by the medical care available at the Leon County Detention Facility, and excruciating pain in her left shoulder, down her arm, and into her hand as a result of an injury received during an attack by another inmate at the detention facility. Within the past few months, Mrs. Adelson has begun experiencing shortness of breath that has reached the level where others comment about hearing her struggle to breathe. Undersigned counsel has actually had difficulty hearing phone communications with Mrs. Adelson because her breathing is so labored that it interferes with phone reception. Have I thanked Mooney and Autumn for this lately? Thank you for my Tumblr, guys. Okay. I got to get rid of this lozenge now. I've got too much going on here. All right. Don't mean to swallow in your ear. Here we go. On a visit to the medical unit with other inmates on February 3rd, 2025, even the medical personnel asked what the loud breathing noise was, and the other inmates pointed at Mrs. Adelson. Oddly enough, when Mrs. Adelson was having a medical visit with a doctor at the detention center prior to February 3rd, the doctor refused to even listen to Mrs. Adelson's chest because that was not the reason we are here, and you will need to get another appointment with a physician's assistant. That is so stupid. I mean, guys, I understand. I get it that it's not Club Med. It's not supposed to be a nice hotel or anything like that. But there should be basic medical care in a jail. And there shouldn't have to be, red tape and hurdles that you have to get over. If you're in with a doctor, they should be able to listen to your chest too. That's so dumb. Okay, on Saturday, February 1st, in the early morning hours, Mrs. Adelson was in the bathroom area and accidentally bumped up against the washing machine, cutting herself on her right arm on a rusted metal bar on the machine. The nurse was in the pod, so Mrs. Adelson showed it to the nurse, who told her how bad it looked, but said she had no Band-Aid. The nurse told her to wrap it in toilet paper so the bleeding would stop, and then to fill out a sick call form to request a Band-Aid and turn it in with the night nurse. that would be there around midnight. So, yeah, this kind of stuff bothers me. If it's true, my goodness, just please take care of the inmates. Goodness sake. Turning it in with a night nurse would mean she would get a Band-Aid the following morning. Unfortunately, the nurse had no sick call forms for Mrs. Adelson to complete, so there was no way to make a request. Finally, on Sunday morning, February 2nd at 10 a.m., a sergeant sent a Band-Aid down for Mrs. Adelson and also provided sick call forms, which Mrs. Adelson filled out requesting that each of her medical issues, including the cut, be addressed. On Monday, February 3rd, 2025, Mrs. Adelson was finally taken to the medical unit. Her wound was cleaned and she received a tetanus shot. You know, I I almost understand. I think I understand why this kind of attitude exists in a jail, and it probably exists because other inmates abuse it. But still, I mean, that's pretty crappy. Cut yourself on a rusted something. You have to wait 24 hours just to get help to get the bleeding to stop. You're a 75-year-old woman. And I'm not making excuses for her. I think she's probably guilty of the crime that she's charged with. But when you're in jail, they should take care of those things. Mrs. Adelson needs medical care that simply cannot be obtained at the detention facility. She needs an appointment with an ear, nose, and throat specialist, an orthopedist, and a physical therapist at a minimum. If she remains incarcerated pending trial, the defense will need to prepare motions to seek permission for Mrs. Adelson to receive care outside of the Leon County Detention Center and obtain a court order for each appointment to be scheduled, which would then require jail personnel to transport Mrs. Adelson to her appointments. Obtaining proper medical care would result in a hardship for Leon County Detention Center and its staff. Oh my goodness, that is great. Oh, okay. Attorney-client privilege. It is impossible for Mrs. Adelson to engage in attorney-client privilege communications via phone communication while incarcerated at the detention center. Within the pod, more than 60 other inmates have the opportunity to listen to her side of conversations. It is difficult at best for her attorneys to hear Mrs. Adelson when she speaks due to the enormous amount of background noise caused by static, phone connection issues on the tablet, and noise from inmates in the background. Mrs. Adelson has had to get onto her bed and cover her head with her blanket so that she can hear counsel and counsel can hear her. On one recent occasion, when Mrs. Adelson ended the phone call and pulled the covers off of her head, there was a guard standing over her listening to her phone call. Again, the thing that we want here, guys, is for there to be fairness in the law. We don't want her conviction, if she is convicted, to be overturned because of stupid crap like this. That is, yeah. It is in society's interest that there be better conditions in a detention facility for inmates to talk to counsel. Goodness sake. Plus, oh my goodness, a guard listening in? That's not cool. Another inmate reported that the guard stood there listening for several minutes of the call. Once Mrs. Adelson ended the call, the guard proceeded to search all of Mrs. Adelson's items and discarded the headphones she uses to listen to recorded materials related to her case, recorded phone calls, etc. Lack of sleep. The schedule maintained for providing food and medication to the inmates at the Leon County Detention Center results in Mrs. Adelson sleeping on average 2 hours each 24-hour period, and many times much less than that. A typical day for Mrs. Adelson is as follows. Nighttime medication distribution, 11:30 p.m. to 1 a.m. Sleep commences after inmates quiet down, 1:30 a.m. Awaken for breakfast, 3:30 a.m. Lay awake in dark on bed until lunch is served, 9:30 a.m. Lay awake in dark on bed until lights on at 3:30 p.m. No, that there's plenty of time to sleep there. Possibly leave bed and walk around in circles for exercise depending on who guard is. Dinner served at 6 p.m., back on bunk until nighttime medication at 12 a.m. No, there's plenty of time to sleep there. Come on. In addition to the initial period of incarceration previously complained of to the court, where Mrs. Adelson was placed in a cell with a mattress on the floor where she had to lay without clothing for more than 50 days, Mrs. Adelson has been physically abused and threatened with abuse throughout her incarceration in the Leon County Detention Center. Yeah. One of the first acts of physical abuse by another inmate took place while Mrs. Adelson was showering and was of a sexual nature. Yeah, okay. So she's living in jail. That's what's happening. Okay. Solitary confinement. Mrs. Adelson has attempted to seek medical care for her pain, shortness of breath, and other health issues for several months, and her requests for appointments have been routinely denied or not properly addressed. However, on Monday, February 3rd, 2025, when she was finally taken to the medical unit and all of her issues, including the cut, were being addressed, the physician's assistant asked about the pain in the left shoulder and arm and how it started. Mrs. Adelson disclosed how she'd been attacked by a fellow inmate. Thereafter, without the knowledge of Mrs. Adelson, the medical unit reported the attack to jail personnel. Within a short period of time, two supervisors at the jail came into the annex and told Mrs. Adelson to roll up her bed and get her bins because she was being removed from the pod. They explained Mrs. Adelson had done nothing wrong and then took her into a room to question her about the attack. Mrs. Adelson was very reluctant to disclose any information because she truly fears retaliation by the aggressor and or her affiliates within the jail, of which she has many that Mrs. Adelson has already had to deal with. Mrs. Adelson finally disclosed all the facts, including the extortion by the aggressor and how her husband unknowingly satisfied the demands by purchasing 2 extra packages of canteen each week to spare Mrs. Adelson of additional harm. Note from October 7th, 2024 to the present, Mr. Adelson has spent $1,150 on this separate canteen. So she is wealthy, they know it, and they're shaking her down. Got it. The jail supervisors advised Mrs. Adelson that it was their responsibility to protect her, and the only way they can do that is to put her into solitary confinement. Therefore, since Monday, February 3rd, Mrs. Adelson has been placed in a cell by herself. She's only allowed outside her cell on Monday, Wednesday, and Friday for 1 hour in the morning, and on Tuesday and Thursday for 30 minutes. When she is released, she has no contact with anyone else and can only use the time to shower, walk on the rec deck, or watch television. Other than that, she is on complete lockdown in a 6x9 room that has a bed, a toilet, and a sink. Note, the toilet is in full view of a window on the door that is approximately, it's jail. Okay, blah, blah, blah. All right, this is the part that I love. Mrs. Adelson, she's no risk of harm to the community. She's, of course, this man is dead, but she's no harm to the community, apparently. Mrs. Adelson is a 75-year-old woman with physical impediments, with no prior criminal history that she was caught doing, apparently, and no disciplinary issues during her entire incarceration at Leon County for the past 14 months. There are no allegations that she personally engaged in any conduct herself that resulted in any harm to anyone, including Mr. Markel. No, there are allegations. Come on. 19, she's not a flight risk. She was going on a vacation to Vietnam, everybody. It was a vacation. Mrs. Adelson has no passport and has been placed on a no-flight list, and thus cannot schedule a flight bound for any domestic or foreign destination. Her husband is 80 years old and would relocate to live with Mrs. Adelson in Tallahassee, Florida, from release through the trial. Okay, here's something that I have to say about that, all right? Wrong button. This button. What button did that show? What was that? Oh, yeah, okay, doesn't matter. All right, so flights are not the only way to travel. That's the deal. They live in Florida. They are surrounded by water on 3 sides. You don't need to show a passport to get into a skiff on the Florida coast. You don't. You you can just go down into the Caribbean. It's not all that hard. Now it'd be risky because there's Coast Guard and stuff like that. But come on, just because she can't take a flight doesn't mean that she couldn't run. All right. Let's see. Legal argument. Yeah, I don't even want to get into that. That's a little down into the weeds. Let's not worry about that. Conclusion. In summary, Mrs. Adelson is being held in the Leon County Detention Center awaiting trial under conditions that will result in her inability to receive a fair trial and unable to adequately participate in preparation for her defense at trial. Her health is failing. She is in constant pain. She cannot hear normal discussions, much less any reduced level speaking with counsel at counsel table at trial, and she is not receiving a fraction of the amount of sleep necessary to assist in her defense. At this point, Mrs. Adelson is aware that the remainder of her time at the Leon County Detention Center leading up to and during trial will be in solitary confinement without any access to interaction with other friendly inmates, art classes, or any other human contact whatsoever, appointments with attorneys accepted. Her incarceration should have ended upon the conclusion of her trial in September. Through no fault of her own, her attorneys were removed from her case, and her trial continued for a period of more than 9 months, thus extending her period of incarceration. So here are the proposed conditions of release. Mrs. Adelson is aware of the seriousness of the offenses for which she has been charged and that the court would not consider the typical conditions of pretrial release, and proposes that in addition to the monetary bond requirement, the court impose the following conditions of pretrial release. 1. Electronic monitoring. 2. Mrs. Adelson will reside with her husband within Leon County, Tallahassee, Florida, pending the outcome of the trial, with the request that the location be shared only with the court, the state, the defense, and the pretrial release officer for the safety of herself and her husband. 3. Comply with a curfew at the residence from 7 p.m. to 7 a.m., with the only exceptions being appointments with her attorneys for court or for medical purposes. No travel outside of Leon County, Florida. Report to a pretrial release officer on whatever schedule is deemed necessary by the court, and any other conditions the court deems reasonably appropriate. Therefore, we request that you grant blah, blah, blah. Okay. That's where we are. Guys, do you think that's reasonable? Do you think it's reasonable that Donna Adelson should be able to leave the Leon County Detention Center and reside in the Tallahassee, Florida area? I think that it's a stretch. Hey, Dom's mom 725. 5 months. Thanks for covering the case. Gavin would love to see Donna Adelson convicted and have to spend the rest of her life behind bars. Rest in peace, Dan Markel. There was Spoongate in jail. You guys. Okay. Gavin, maybe she will expire and save the state the cost of a trial. Queen Anne, question not necessarily for Gavin, but did hear the ear canal shrink since she has been in... But did her ear canal shrink since she's been in jail, or she's always had the problem? She claims she's always had the problem. Let's bring our victim up here. Let's see. Gavin, I doubt they have breakfast at 3:30 a.m. and lunch at 9:30 a.m. Then make them wait till 6 for dinner. Yeah, that seems weird. Chickadee says, Gavin, Mrs. Adelson has been pampered and entired her entire life. Jail is what it is, not a 5-star hotel. KG says, Gavin, hi. Bit late, but made it. Happy Valentine's Day to the entire fishbowl, especially you amazing mods. Thank you very much. My mods are amazing. Gavin, jail says, Demon Hugger's friend. Jail isn't a vacation, but Vietnam has to be. That is funny. You guys are hilarious. Gavin has more followers on YouTube than Vinny Politan. Yeah, Gavin's been at it longer, and don't worry, Vinny will surpass me soon enough. That's funny. Cooler by the Lake. Gavin, odd that they agree to relocate to Tallahassee, the very thing they wanted to avoid. The irony is there. The irony is there. Great catch. Okay, guys. I think that's it for this Friday night. Go spend some time with someone you love, will you? It's Valentine's Day. Go find that person that you love and spend time with them. And we will be back on Monday at 7:30 p.m. Eastern for our next show. Plan on doing a show every day next week like we did this week. So if you haven't subscribed yet and you like this kind of content, please do. Jennifer Hardy, you're late. What did you miss? You missed everything except for me bidding you adieu. I hope to see you next time. Take care. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.